Hello, this is the next in the series of presentations on the Jackson reforms, and this one is on the disclosure of documents. In paragraph 311 of his final report, Sir Rupert Jackson addressed disclosure in large commercial cases. He said that this was the one area of litigation in which a clear majority view emerged during his costs review. The general view amongst commercial practitioners and judges was that a menu option is the best way forward. That means a menu of levels of disclosure obligation, of which standard disclosure would be just one. A draft rule encapsulating a menu approach was initially prepared by the Disclosure Working Group, and that draft underwent a number of revisions following consultation meetings, and the new CPR 31.5 is based very heavily on that draft, although the proposal that it should apply only to £1 million plus cases has changed, because now it applies to all multi-track cases. In a small claim or fast-track case, on the other hand, there are no major changes in this area, and by CPR 31.51, an order to give disclosure is an order to give standard disclosure unless the court otherwise directs. The court may dispense with or limit standard disclosure, and the parties may agree in writing to dispense with or limit standard disclosure. But when it comes to multi-track cases, by CPR 31.53, not less than 14 days before the first case management conference, each party must file and serve a disclosure report verified by a statement of truth. A disclosure report must describe briefly what relevant documents exist or may exist, describe where the documents are and with whom, describe how electronic documents are stored, and estimate a range of costs for giving standard disclosure, and state which disclosure direction is to be sought. Additionally, the party serving the disclosure report must file any electronic documents questionnaire. Then, by 31.55, not less than 7 days before the first case management conference, the parties must, at a meeting or by telephone, discuss with each other and seek to agree a proposal in relation to disclosure that meets the overriding objective. Should the parties succeed in agreeing proposals for the scope of disclosure, then if the court considers that the proposals are appropriate in all the circumstances, the court may approve them without a hearing and give directions in those proposed terms. Otherwise, at the first or any subsequent case management conference, the court has to decide, having regard to the overriding objective and the need to limit disclosure to that which is necessary to deal with the case justly, which order to make in relation to disclosure. Now that implements Sir Rupert Jackson's menu recommendation. The menu itself is set out in 31.57, and it sets out the types of disclosure order available in multi-track cases. A. An order dispensing with disclosure. Now, such an order might be appropriate perhaps where the parties have already given extensive and sufficient pre-action disclosure, or where the case follows on from another in which all necessary disclosure has been given, or perhaps where the case could and arguably should have proceeded under Part 8 in the first place. B. An order that a party disclose the documents on which it relies, and at the same time request any specific disclosure it requires from any other party. Now, this type of disclosure is common in other jurisdictions, especially civilian systems, and it'll be familiar to those involved in international arbitrations in which procedures reflect those in civilian systems, for instance, under the ICC rules or the LCIA rules. It offers the prospect of much more targeted disclosure, and although Anglo-American lawyers are often deeply suspicious of it because it dispenses with the duty of adverse disclosure backed by the lawyer's professional conduct obligations to administer adverse disclosure correctly, see the House of Lords decision in Myers and Ellman, certainly this style of disclosure seems to satisfy lawyers who are used to these procedures. C. An order that directs, where practicable, the disclosure to be given by each party on an issue-by-issue basis. Now, this type of disclosure offers the possibility of two different types of focus. First, the court could specify the issues to which disclosure is to go, and secondly, it could require the parties to, as it were, pin their colours to the mast by stating to which issue any given document goes. Well, the risk seems to be that where, as will often be the case, any given document goes to multiple issues, that document will have to be listed multiple times, and if that is so, it will make the process more burdensome and not less. D. An order that each party disclose any documents which it is reasonable to suppose may contain information which enables that party to advance its own case or to damage that of any other party, or which leads to an inquiry which has either of those consequences. Now, before the Civil Procedure Rules came into force in 1999, the scope of disclosure was defined at common law, particularly in the Peruvian guano case. Now, Peruvian guano disclosure was a wider scope of disclosure than that later defined in the Civil Procedure Rules as standard disclosure, and that was so in two respects. First, Peruvian guano disclosure included documents relevant to the case. Now, that brought in background documents. It also brought in documents which might enable the other side to advance its own case or to damage that of another party, or which might lead to a train of inquiry having that effect. Now, the mode of disclosure which we are discussing here, offered in the menu, provides the second of those two wider aspects of disclosure, but it doesn't permit or require documents to be disclosed merely because they are relevant, in the sense that they pertain to the underlying transaction or generally tell the story. It's thought that this type of disclosure is particularly appropriate where there are allegations of fraud. An order that a party give standard disclosure. Now, standard disclosure, which remains the default position in small claims and fast-track cases, and which has, since the Civil Procedure Rules, also been the default position in multi-track cases, now, of course, becomes just part of the menu. It probably needs no introduction, but by way of reminder, the disclosing party under an order for standard disclosure must disclose the documents on which he relies, the documents which adversely affect his own case, the documents which adversely affect another party's case, and the documents which support another party's case, and in addition must disclose those documents which that party is required to disclose by relevant practice direction. F. Any other order in relation to disclosure that the court considers appropriate. Now, this final category of disclosure seems to offer scope for tailor-made disclosure orders and creativity. No doubt, in practice, attempts will be made to use it as a backdoor route for obtaining disclosure orders which are covered by more specific rules with more restrictive criteria, maybe experts on privileged instructions. But it can be expected that such attempts will be unsuccessful. Now, the substance of scope of disclosure obligations will be defined by the disclosure orders, which we've just had a look at. But turning to procedure, that procedure is now governed by CPR 31.58, under which the court may at any point give directions as to how disclosure is to be given, and in particular, A, what searches are to be undertaken, for what, in respect of which time periods, and by whom, and the extent of any search for electronically stored documents. B, whether lists of documents are required. C, how and when this disclosure statement is to be given. And D, in what format documents will be disclosed and whether any identification is required. E, what's required in relation to documents that once existed but which no longer exist. And F, whether disclosure shall take place in stages. Now, that's all on this short presentation on disclosure of documents.